Good morning, everybody. Thank you all for joining us. I think, are all in from the waiting room. That was I think the fastest ever. I am going to start by welcoming you all to our Q&A this week, as I do every week. And also I'm going to start by walking you through some of our Zoom housekeeping tips. So the first one is that if we could all stay muted unless we need to unmute to ask a question, that would be great. It just helps cut down on background noise and makes for a better recording too, as an aside. And your mute or audio button is going to be in your Zoom toolbar, which is also where your video button is. You can use those to be on camera or off as you prefer. And that's also where you will find the chat button. And the chat, I just put a message into the chat, so that might be blinking. You can look at that. That's also where you should put any questions that you have for us today or any requests for clarification. I will offer that we have a sum total of 3 questions that were submitted to us in advance this week. So we will very likely have time to pick up almost as many questions as you might put into the chat today. We do have a primer on a subject that we prepared to fill a little bit of extra time in case we don't have many questions in the chat. So don't feel like you have to make stuff up for us to answer, but if you do have questions, we'll be happy to get to those once we're done with the few that we've got prepared. As we do remind you every week that we are here not to give legal advice, but to talk generally about helpful legal information for community associations in Washington state. So sometimes your questions are very, very specific, either in terms of the facts that you provide us or in terms of asking about interpretation of your governing documents. And those types of questions we just can't answer in this venue. And so when Chelsea emails you back to say, this is too specific and we can't cover it, don't get mad at her, because I'm the one that makes those judgment calls. And to the extent that we can, we'll try to cover the topic generally if we think that it's broadly helpful to people, even if we can't answer the specific question that you have submitted. As the message in the chat reminds you, if there is a question that we don't get to today, or if you think of another question before next week's Q&A, please email them to info@condolaw.net by 4 p.m. on Monday so that we can add them to our list for next week. And if you ever miss a Q&A, you are welcome to go to the link that's in the chat, which is for our YouTube channel, where we've got all the videos since we started doing this 5 years ago. So you can search the YouTube channel for subjects and videos that you think are relevant to the issues that you care about right now. We have been reminding you guys for a while now, since the start of the legislative session, about the Monday morning minute emails, and I'm going to put a link for that into the chat again and remind you that if you haven't signed up yet this legislative session, please consider doing so. If you signed up last year, your sign up was purged and you have to sign up again every year for some reason. I'm not exactly sure why, but the link is in the chat for that. Last week alone, well, in the last 2 or 3 weeks, we've had, I think, 3 or 4 calls to action by way of the Monday morning minute email list, where there are bills that are currently being negotiated in our state legislature that have the potential to significantly impact community associations. And so we try to keep you updated on those generally via the Monday morning minutes, but also sometimes we send out calls to action if we think that a bill is serious enough to warrant either strong support or strong opposition from our community. So that's one of the many reasons to sign up for the Monday morning minute emails. I'm going to skip the CTA update, other than to say that they're not enforcing it in the United States against American citizens or US companies. You can look at our last couple of Zooms to get a little bit more detail about that. You can also look at the update that I posted on my LinkedIn if that's of interest to you to learn a little bit more there. We've also been reminding everybody about the annual conference. WSCAI's annual conference is coming up at the end of this month. It's April 24th to 26th. We are going to be there, and we would love to see any of you that are also going to be in attendance. Come say hi to us at our booth, or come listen to me talk and Katie and Ken talk, sadly all at the same time, but that's okay. It's just the way the cookie crumbles sometimes. So we're going to be talking about, I'm doing a legislative update generally. Ken and Katie are going to be talking about the WCAI for all, and some of the things that you need to know about as a community that's going to be governed by WCAI eventually. So I put a link in the chat for the WSCAI event page. If you haven't already purchased tickets to attend that event, we would encourage you guys to do so. I think that's all I've got for prep today, unless you can think of anything that I'm missing, Katie.
No, I think you covered it, and I'm just trying to, okay, there we go. I had accidentally covered my notes with the chat that was empty. Anyway, so I will jump into the first of our 3 questions. Again, put any clarifications in the chat or any new questions. So the first one is, are the unit owners allowed to fill the vacancies on the board in the middle of the year? If so, what is the order of doing that? So as always with these types of questions, first look at your governing documents. Your bylaws may have, or your declaration, but usually your bylaws may have some specific process on how to handle vacancies. It may say that you can fill the board can fill the vacancy for the unexpired term. It may say that you have to call a meeting and elect someone to fill the vacancy. It may say that the board can fill a vacancy until the end of the next annual meeting, even though that may not be the term. So it's going to depend on what your governing documents say. Typically, in most communities, the remaining board members can appoint a volunteer to serve out the remainder of the term for the board member that steps down. This would not require a mid-year election or any involvement from the ownership as a whole, but it can. The board could decide to have a mid-year election to fill the vacancy. Again, it's not necessary, maybe by your governing documents, it's definitely not necessary by the nonprofit statute, but you can. The process of doing it would be the same as an election for your annual meeting. You would just call a special meeting to fill the vacancy. You would send notice to the owners, hold the meeting, and then that person would, if they're elected, would start serving. You also don't have to appoint anyone to fill a vacancy. We see this when you can't get a volunteer to fill the vacancy. A board can operate with less than a full board. It's not ideal, and we typically recommend it be a last resort, but it is an option, especially for smaller communities that can't find a volunteer. Valerie, do you have anything to add?
Yeah, the one thing I'll add is some of you might be wondering, well, why do you not recommend that? And I think there's many reasons. One is that having an even number of board members makes it harder to make decisions unless the board members are always in agreement with each other, because you can have tied votes, and then how do you break the tie? The other is that, let's say that you're a community that operates ideally with a full board of 5 members. And then one member sells their unit or decides to resign, and now you're operating with 4 members. And over the years, you drop another member or 2. It's not inconceivable, and it is something that we have seen before, where sort of a community will realize, like, oh man, we've only got 1 board member left and they're about to sell their unit. What do we do? Right? So you don't want to start down that path, because often you end up at the end of that path very quickly and sort of without realizing how fast that eventuality is coming up on you. And so trying to maintain a full board with as many members as are allowed or required by your governing documents is just it's a best practice that we that helps you not end up in that situation where you're like, crap, what do we do?
Yeah, and I will say, just bouncing off that, we in the past year have had a few clients that have gotten down to 1 board member, and it's really stressful on that remaining board member. They feel like they can't sell their unit, but they want to move on. It also puts a lot of stress on projects that need to happen, because you're basically, it's 1 board member making all of these decisions. Yeah. Which, yes, they have their duty of care and obligation of good faith and all that, but it's still a lot to put on 1 person. So if you need to call a special meeting to fill a vacancy because you don't like any of the volunteers you have to appoint, that's better than a wish and a prayer with 1 person.
Definitely agree with that. All right, I'm going to move us on to our next question. Under Washington state law, can you send either a retired military veteran or active service member to collections and or apply late charges or fees to their account as an HOA or condo association owner? So the short answer to this question is yes. The long answer is that it does. There are some impacts on what you or what your association attorney more accurately can do when you're dealing with an active duty service member. So I'll start by saying that with respect to military veterans that are no longer active duty, they're no longer serving at this time, there are no limitations or differences in the process or the options that are available to you. With respect to active duty service members who are currently serving, you can still record a lien, you can still assess late charges and take most other actions that you would against non-service members. The only things that are affected by an owner's active duty military service are the rate of interest that you can charge on the debt when you're seeking a judgment, and also certain steps that have to be taken on the legal side of things once litigation has started. So I guess the simplest way to boil this down is that on the management / association end, when you're just like looking at your collection policy and looking at your delinquency report and wondering what your options are about, late fees, delinquency notices, referral to your association attorney, their service does not necessarily change things on your end. That is not to say that it's irrelevant, and it wouldn't be unreasonable for a board to consider an owner's military service, especially their current deployment, in determining whether it's reasonable to vary from the uniform application of, for example, the timeline in your collection policy. So if you usually refer accounts to your association attorney at the 6-month delinquency mark, but you know that you've got an active duty service member who is currently deployed and is going to be home in 3 months, who has no history of delinquency in the past, and you're not able to communicate with that person while they're gone, I think it is reasonable for a board to say, in this particular situation, because of these facts, we're going to slow our timeline down a little bit, wait for them to be back in the country before we make a decision about whether to refer them to the association attorney. I don't think you have to do that, but I think you can do that if it seems reasonable to the board under the particular circumstances of that situation. The Service Member Civil Relief Act is a federal statute that does affect how your attorney can process, how we can proceed in some ways once we are litigating the delinquency against a unit owner, or a homeowner. So for example, there are limitations on how you can obtain a judgment. A lot of the times when we're dealing with non-service members, we will file a lawsuit, we will personally serve that lawsuit on the homeowner. And often it's kind of shocking to some people, but I've done this for long enough that it's not shocking to me anymore. A lot of times people just ignore it. They get served with the lawsuit and they just ignore it. They don't respond. And so you can go to court and basically tell the court, we served them personally with the lawsuit, they haven't responded, and then you can get a judgment by default, which is essentially a judgment where you're not holding a trial, you're not notifying the owner of the judgment because you've already notified them of the lawsuit and they've ignored it, and you can prove to the court the specific balance due. That's a process that allows you to get a judgment by default against the homeowner. Under the SCRA, the Service Member Civil Relief Act, you cannot obtain a judgment by default against an active duty military member who is currently deployed. If they're not deployed, it does change things a little bit. The SCRA also caps the rate of interest that can be charged on a debt that's owed by an active duty or deployed service member. So most of our association documents charge a rate of interest of 12% per year. Occasionally they say 10% per year. 12 is the maximum allowed by Washington state law. The SCRA caps the rate of interest on these debts at 6%. And so sometimes you might see a ledger from your association attorney that says 6% interest, even though your documents say 12% interest. And if I'm the one handling this, my client already knows that it's because they're in the military. I've already explained that to them. But if you're ever confused about why you see that, it should be a simple question to your association attorney as to why that interest rate is different than you're expecting. Another thing that sometimes happens when we're handling a lawsuit like that is that we will have to ask the court to appoint an attorney to defend or represent the deployed service members' interests, even if they haven't responded to the lawsuit themselves, and even if they haven't hired their own attorney. This doesn't happen super often, and it's confusing enough to the courts that sometimes, like I had a case recently where we filed a motion asking the court to appoint a civil attorney to represent the service member's interests when this person was deployed. And I think the judge misunderstood the motion and appointed a criminal defense attorney, a public defender, to represent them in this civil lawsuit. And so we had to present a clarifying motion to the court to basically say, no, a criminal defense attorney is not what we're asking for here. So this is it's not something that we deal with super often, but it does happen every now and then. But to go back to the original question, on your end of things, when you're just talking about assessing late fees and proceeding through your normal collections process, it doesn't affect what you're allowed to do. One thing that I would think would be really fantastic, though, is if when you send it to your association attorney, tell them that the owner is an active duty service member. We don't know that information, and it's not always easily available to us, and certainly not in the very early process where all we're doing is looking at whether recording a lien and sending a demand letter is a reasonable step, given the amount of the debt or any other factors that we consider. It's not until we get into the litigation process that we pull information on the owner that tells us whether they might be in the military. And so if you do have that information, include it in the referral packet or email or whatever it is that you send to your association attorney so that they're aware of it from the outset. It's just the more information that we have, the better. Katie, did you want to add anything to that?
I was going to ask you a question of how you know if someone's in the military and deployed or not, but then you covered it at the very end.
Yeah. So when we file a lawsuit, we do a search in a federal database using the owner's name and the last 4 digits of their social security number, I think. And that tells us whether they're active duty or not. It does not tell us whether they're deployed. And so again, if that's information that you guys have as managers or board members, make sure you get that information into your attorney's hand, because it can be really useful for us. It also can provide a really, as a practical matter, not even a legal matter, nothing with regard to the SERA, right? But if you know that they're deployed and they're on a ship overseas for the next 4 months, then we know why they're not responding to the mail or why they're not picking up their phone when we try to call, right? And so it's just practical information that helps us advise you from the most informed standpoint possible about what your options are, what our recommendations are, and what we think reasonable next steps are.
All right. So this is our last question prepared in advance before our primer. So if you have any questions, now's the time to put them in the chat. And I haven't seen any, so
we have
No,
one. We have
okay.
one that came directly to Chelsea, but otherwise we'll do our primer.
So this last question is, which board member has the authority to set the agenda, and what exactly does that have to look like in terms of specificity? So as I mentioned with the first question, some of this information may actually be found in your bylaws. Some bylaws specify an order of business for association and board meetings. Sometimes it's just association meetings, like the annual meeting and stuff like that. But sometimes it does have a skeletal outline of your board meetings. Generally, the board president sets the agenda for the meetings, but the board could also agree on a standing agenda that is used every time. The agenda does not have to be formal or follow a template out of something like Robert's Rules of Order, but it can. Some bylaws will say that basically anything that's not in the bylaws you use Robert's Rules of Order for. So you could use it to set your agenda, but the agenda should follow the typical order of business for a parliamentary meeting. So that looks like a call to order, approval of the last meeting minutes, old business, new business, and then an owner forum if you hold one. I will say the changes in Ukiah that we are expecting to take effect for everyone for meeting requirements for board meetings. Again, it's just proposed, but if it does take effect, it'll apply January 1st of 2026. That will require the owner forum to be at the beginning of the board meeting. That makes sense. It's so you can comment before the board makes an actual decision. Why would you comment at the end after the board's already decided? That change will set a specific amount of time and for people to speak and also for the duration. So you'll be able to cap it so someone can't monopolize the whole conversation if other people want to speak, but you won't be able to say, oh, you only have 60 seconds for all the owners to talk. We'll talk about that more as if it becomes effective, and so we can prepare everyone, because will apply to everyone. But that's your general order of business. Call to order, approval of meeting minutes with the new changes, the owner forum, old business, new business, adjourn the meeting. And that can work for both your annual association meeting or for your monthly, bi-weekly board meeting. Under the old and new business sections, you can list specific subjects. Generally, if you know that you'll be discussing the landscaping contract or the date that the pool will open, you can put those there. Otherwise, it can just say old business, new business. If another board member wants a topic added to the agenda, they can just contact the board president or the manager if it's appropriate and request that the item be added. Generally, the board president should say yes and include the requested topic on the agenda unless there's a compelling reason not to. So, for example, if you want to, you're not the board president and you want the board to talk about a landscaping contract, that makes sense. If you are not the board president and you want to talk about how crappy the weather is, then probably not going to be added. So don't expect everything to be added, but if it's reasonable and it relates to the association, that should likely be added. The board as a whole can then decide at the meeting whether or not to vote or have a detailed discussion on each agenda item that will take place. So you don't need to, if you've already talked about the old business of what you want in the landscaping contract and now you have it and it says exactly what you want, you can just vote to approve it. And not everything needs to be a 20-minute discussion. The agenda should be included in the notice to your owners about the open board meeting. If you're an open meeting community, everyone will be an open community soon if this legislation passes. But if you have a standing agenda and a standing board meeting, you can just keep sending that, or keep the standing agenda with the standing board meeting invite if you have a calendar invite or over Zoom. If the question is about association meetings, you'll need to include the following in your notice to the owners, and I'm going to read it. All items on the agenda, including the text of any proposed amendment to the declaration or organizational documents, any changes in the previously approved budget that result in a change of the assessment obligations, and any proposal to remove a board member or officer. So those are all things that would need to be included as well as the agenda when you send it out to the owners. And it's especially important for, like, if you have a proposed amendment, it is not enough to have owners vote yes or no if they don't have the actual language. So you can do a straw vote and say, hey, are we interested in this? But if you actually want an amendment to pass, you need to give them the language first. Valerie, anything to add?
I will just offer as an aside that this question was originally very specific in the way that it was submitted from the person that asked it. And we had to notify that person that it was too specific for us to cover, because in the way the question was asked, it was really a request for legal advice, even though I know that sometimes y'all sort of accidentally ask for legal advice, even when that's not your intention. So this is one where we just had to kind of generalize the question and answer it in a way that we thought was as broadly helpful as possible. The other thing that I'll say is that I think a lot of times when it comes to things like agendas and minutes, people think that there's like a super formal, like legally correct, precise, technical way of doing things. And that is almost never the case. So I think you guys are, I know that these questions come from a place of wanting to do things correctly, which is a motivation that I deeply appreciate, especially because I'm an association attorney, right? And we want our clients to do things correctly as much as possible. And also, sometimes I think that that sets you all up for feeling like, unless you do things in a really specific technical way, that you're doing things wrong. I think, for example, when it comes to the question of setting the agenda, erring on the side of including every topic that's suggested by any board member is a great way to go, because then at the meeting as a board, you can decide either this topic is ripe for discussion and a motion, or we're going to table it for the next meeting because this is not a pressing issue for our community right now. I also think that when it comes to things like the agenda and the meeting minutes, one of the things we know the legislature cares a lot about, and one of the things that we have always told our clients that is really important, is transparency with your ownership. And so erring on the side of disclosure, always being accurate, of course, but erring on the side of disclosure is sort of it's a mistake that we don't think will come back to bite you when it comes to liability or risk for your association, right? When you're trying to be as transparent with your ownership as possible, we think that almost always ends in a better place than certainly than hiding information from your ownership. So we have a flurry of questions now that just came in from the chat. And so I'm going to read through the questions and we will get through as many of them as we can. The first one is, where can a board go to learn about powers of attorney and what we are to look for if we're handed one by an owner's child and they say that all information is to go to them and not the owner? I have a short, easy answer to this question, and then I would love to hear if Katie has anything to add. And my short, easy answer to this question is, you send the power of attorney to your association attorney and say, is this valid and enforceable? And if it is, then you comply with the request of the child or the person who is the holder of that power of attorney, because they essentially stand in the shoes of the owner. That's the whole point of a power of attorney document. But I think there are too many moving pieces in a power of attorney for me to recommend that a layperson try to determine whether it's valid and effective. Some of those moving pieces would include the fact that sometimes powers of attorney are drafted to take effect immediately. Other times they're drafted to only take effect upon the disability or unavailability of the principal, the person who issued the power of attorney. Sometimes powers of attorney include everything: financial, real estate, healthcare decisions, all of that. Other times powers of attorney are drafted to only cover a very narrow subset of decisions that can be made on behalf of the principal. And so you don't want to be the one guessing about the validity of that document. So my recommendation would be, send it to your association lawyer and have them tell you if it's effective and what you should do in response to the request. Katie, did you have any additional thoughts to add?
Yeah, and you can, I don't know, I don't think this is a disagreeable position, but you might. I think it also depends on what you are being presented with the power of attorney for. So if someone is presenting it to you because they want copies of annual meeting notices, they're going to be sent out so that they can make sure, I don't know, their parent attends or whoever they're caring for. That's different than it being presented for a vote at a meeting or for a collection file and they need to speak with the attorney. So in the grand scheme of things, what it's used for may depend, and it may be specific for things, as Valerie was mentioning, but it also may be that if it's for like notices and this unit has a horrible lawn that is totally overgrown and it's to get violation notices, it may be appropriate to send notice to that person to help you get the result you want for compliance. And so, yes, send it to your association attorney, but also think about what it's being used for.
Yeah, I think that's a great point. I also think that if you want to be ultra cautious, first of all, ultra cautious includes sending it to your association attorney. So this is not an instead of, but in addition to that, you could also send notices to both addresses. So if you don't feel comfortable changing the address and sort of cutting the owner out of the communication loop entirely, even though that might be appropriate based on the circumstances and what the power of attorney is for, then you could also just decide, sure, we'll send everything to the power of attorney person, but we're also going to keep sending everything to the owner. All right, our next question from the chat is, if someone is in collections and is in the process of being served, what is the extent they will go to before they will say that all good faith attempts have been exhausted and give up? And then what happens next? So I will say, I'll go ahead and take this one since I do a lot more collections, but I'm going to start by saying that this is true regardless of whether the lawsuit that's being served is a collections lawsuit or a general lawsuit, a compliance lawsuit, any other type of lawsuit, okay? Personal service attempts, there isn't a statute that gives you a formula for like, if you attempt service like 8.5 times, then you've complied with the requirements, because it depends on the circumstances. So let's say that we have information suggesting that a unit owner lives in their unit, and we send the lawsuit for service at that unit, and the server goes, they could go 20 times, but if they always go at the same time of day, that might not be considered sufficient service attempts. So whenever we send our lawsuits out for service, we specifically ask the servers to try serving at various times of day and various days of the week, including the weekends, because we know that different people have different work schedules. And so some people work nights, some people work Monday through Friday, 9 to 5, and we need to make sure the service attempts sort of take that variation into account. Another situation that I can think of that would warrant fewer service attempts is, let's say the server shows up at the house to serve the lawsuit, and it is very clear that the house is vacant. There's 27 newspapers on the front porch, and they look in the front window and the house is empty, and they knock on a neighbor's door and the neighbor says, oh yeah, they moved out 6 months ago. There hasn't been anybody here since. You don't have to keep trying to serve at that clearly vacant address. There's other things you probably have to do though. And so this is part, it's built into our process whenever we litigate on behalf of our clients. We will work with an investigator to see if we can determine another address or two at which to try to serve them personally. And then as a last resort, if we exhaust a lot of different options and we can prove to the court that we took all reasonable steps possible to serve them personally, the fact that they own real estate in the community that is trying to sue them is a basis for us to file a motion asking the court for permission to serve them either by mail or by publication in a legal publication, like the King County Daily Journal of Commerce or something like that. I would estimate that probably 15, 20% of the time, we are not able to serve someone personally. And then we do have to go through that sort of list of exhausting all of our different options, and then file a motion to the court, include a declaration telling the court all the things that we tried, including we also send the lawsuit to them by mail, because our hope is that, like, let's say we know we have what was at one point a valid address for someone, we send it to them by mail and hope that mail forwarding gets it to them, because our desire is to avoid litigation whenever possible. We work really hard to do that. But also, once we start litigation, it's not like, well, we started, we're going straight to the end on this thing and we're going to ignore any possible efforts to resolve this dispute. No, our desire is to actually sort of put the owner in a position where they basically can't help but respond, right? Getting served with a lawsuit does generate that kind of response sometimes, and allows us to negotiate resolutions, payment plans, other things that can avoid the sort of ongoing nature of that litigation whenever possible. So I think that answers the question. Katie, if you have anything to add, feel free. Otherwise, I can bump us on to the next one.
Hey, let's move on to the next.
Okay. Next question. Does a board need to sign and file in their records a resolution when the 7604 ruling is approved at an annual meeting? Or do the minutes of the meeting represent the approval for the CPA? Would you like to take a stab at this one, or do you want me to do it?
I will let you do it, unless I don't know what a 7604 ruling is. So
yes, as a 7604 ruling, for those that don't know, is a ruling that allows homeowners associations, when they file a certain form, to avoid having to pay income tax on surplus income from assessments by refunding the surplus to the ownership. And I cannot tell you what would be good enough for a CPA, because I am not a CPA. So the real answer to this question is ask your CPA what they want. From a legal perspective, if the board has sent proper notice of their open meeting, for example, if it's an open meeting community, they have properly, they establish quorum at their board meeting, somebody makes a motion, the motion is seconded, you follow all the correct processes, and then you document the ultimate board decision in the minutes. From a legal perspective, that is a valid and enforceable board decision, in my opinion. But that does not mean that your CPA might not want that decision to be translated into the form of a resolution that's signed by the board. Anything to add, Katie?
Nope, I agree now that I know what it is.
Okay, great. All right, next question. If a prior board, against the attorney's advice, makes an exception for a homeowner, for example, choosing not to enforce a covenant, and the board gives the homeowner a signed letter allowing the exception until the property is sold, is the current board required to abide by that board's decision? And Katie, I'm going to lob this one to you, but I'm going to give you a piece of information first, which is that this was emailed to us and I vetoed the question as being too specific. So if you want to share anything that you think is very general in response to this question, feel free, but also feel comfortable saying, nah, you're right, this is too specific and we're not going to answer it here.
Yeah, I think it's too specific, but I will say generally, any board looking to undo a past board's decision, I guess the question is why? Yes, there are reasonable times where you might disagree with how, like, the paint color that the prior board picked, and you are now in that position where you can decide, no, I want marigold instead of gray. That's different than going back and changing board decisions that were reasonable at the time, that they're like, why would you change it? And so some things you might not be able to change. If a prior board has settled a lawsuit, for example, with a collections matter, I don't think a new board can undo a payment plan that was agreed to, I guess, make it less favorable. They might be able to make it negotiate a new one, but I don't think they could take it away. And Valerie, you could probably correct me if I'm wrong. So there are some things that you can undo as a new board, but I would talk to your association attorney to figure out what is reasonable and your motivations for doing it.
Yeah, that absolutely, that last statement boils it down for me, which is, I don't know enough information. I want to know why you want to undo this. And you need to talk to your association attorney to get an answer to this question, because it's legal advice and we can't do that here. So, all right, next question. Any suggestions on how to deal with a situation involving a board member who presented significant false information in a candidate statement? I'll start and then let Katie do the lion's share of the work on this one. And I think part of where I would start is it depends a little bit on where you're at in the process. So if you're talking about a candidate statement and the election hasn't happened yet, and you know for sure that the information is false, like you can verify and have evidence that it's false, then there's no reason that at the election you can't basically correct the record with the homeowners, and just say, like, so-and-so statement included this claim and that claim. Our understanding is XYZ. And then basically present the contrary evidence to your ownership and let them make the best decision possible with the information that they have. If it's after the fact, I think your options are different. And I'm going to go ahead and defer to Katie on the rest of this question in case, because you're nodding your head over there. So I think you have.
Well, I'm agreeing with what you're saying. Yeah, let the owners decide. If they don't care that it's false, then it is what it is. But if it's after the fact and they didn't know that it was false, I guess one, as I think I've mentioned a lot, depends what it is. I mean, if they said they lived in the community for 20 years and they've only lived for 15, like, does it matter? But if they're saying I was a former board president at X association with 200 homes and I managed all the books and I have X experience, that may have made a difference. And that's not true. That may have made a difference in how people vote. And so you could now present that information to the owners and let them to decide what to do. Bylaws allow removal of board members by the owners. Board members can't remove other board members unilaterally, but you could share that information and let the owners decide if they would like to recall that person or if they care. And so it just is going to depend on your community, your community's interest in removing a board member, because let's say it's hard enough to get people to serve on the board and vote for people to serve on the board. It is even harder to get people to actually recall a board member once they've been appointed. And as I said, it depends on what the information was. If it's really not going to make an impact, I mean, you could share it with the community, they may not care, but in the end, you could also just correct it in the minutes and say he actually was not a board president and leave it at that.
Yeah. And I think, not to sound like a broken record, but I would say this is the kind of question that if you serve on your board would be very appropriate to submit to your association attorney and say, like, what should we do about this? Does it rise to the level of something we should take action to correct? If it is something like, oh, you find out after the fact that this person has been convicted of fraud in the past, that would be directly relevant to their fitness to serve on the board, your community's trust in their ability to act in the best interest of the association, to not act in a self-interested way, but also it could impact your insurance coverage. So it really does depend on the nature of the statements or the falsehood or the dishonesty. And I think only your attorney can give you solid advice about how to handle that specific decision. All right, we have one other question from the chat, and then after that, we can jump to our other topic. And the question is, can a COA or HOA require that owners have estate planning documents in effect before they pass? And the answer is no. And I don't know if you want to add anything else to that, Katie.
I think it's no. I think that certain communities, you could maybe amend your documents to, like, just like you could require a background check. I think you could put in your declaration they have to have this. I don't think you could judge the validity of it. I think just proof, maybe, but I would still say no. But a way to get around this is maybe not, you don't have the documents, but have an owner contact form that lists emergency contact. And then if the concern is what happens if someone dies in the unit and I don't have anyone to contact, you have an emergency contact instead of all these estate planning documents that you don't need and not everyone has. And some people don't even want to do estate planning. They just want to do probate that exists as the courts have structured. So if the plan is what do we do, or the question is what do we do with the unit when someone dies, then just have an emergency contact for all your owners and ask them for that information.
Yeah, and I'll offer that I mean, first of all, estate planning documents are not free. They can be expensive. And so imposing I don't see how any judge would, even if you amended your declaration to make this a requirement, I don't see how any judge would decide that that was reasonable for you as an association to encroach on somebody's personal decisions in this way. And also, I will offer that I have seen units and houses where the owner has passed and they did have estate planning documents. And that does not necessarily make things any less complicated than when they don't have estate planning documents. And one thing that people might not be aware of is that every state, and Washington is no different, has statutes that are called intestacy statutes. And those statutes basically dictate what happens to somebody's property when they pass away without a will or other estate planning document. So it's not as though there isn't a way to determine who inherits the interest in a property when someone passes away without estate planning documents. But I see way too many privacy issues here. I don't see a judge in the world deciding that it's reasonable for you to require this, given the cost for people to have valid, enforceable estate planning documents. And I also think it's one thing to try to require that they have them, but are you going to ask for copies? And what entitles you to, I mean, we don't want our clients asking for copies of people's personal financial documents like this. So I just think there's way too many landmines in a situation like this. And I would tell a client not to do this.
Well, and also what happens if they don't provide it? If they don't provide it and they've already passed away and you didn't know they didn't have it, what's the point? There's no enforcement. There's no way to get it. So yeah, I would also say no.
Bad idea. Well-intentioned, I'm sure, but bad idea. All right, we are done with the questions that are in the chat. So we're going to jump to our topic that we had prepared ahead of time just to talk a little bit about, which was basically a primer on levying enforceable fines. And I wanted to start by saying, I'm sure some of you might be like, why are you talking about this? You cover this probably 20 times a year in the last 5 years. And the reason that we're talking about it is because despite the fact that we think the process is relatively clear to us anyways, and it hasn't changed in a really long time, we still continue to see a lot of errors in how our clients actually do the process. So we try to cover this topic every now and then as a reminder and a refresher to everybody. And one of the things that you will hear us say often, if you hang around with us for any period of time, is that when homeowners attack association actions, and in particular when they're successful at doing so, it's almost always because of a failure to observe the correct process as opposed to the actual substance of the action or the decision that they're trying to attack. So in other words, somebody might actually be totally violating your association rules, but if you don't do the fine process correctly, your fine is not going to be enforceable. And, on the one hand, some people might say, like, why do we care? Fines are about gaining compliance, not, when we say this all the time, not creating an income stream for the association. And so just sending a notice telling them that they're being fined might be enough to prompt them to bring their unit into compliance. And if that's what you really care about, then what does the rest of it matter? And the reason is that sometimes that doesn't actually work. Sometimes assessing the fine alone does not prompt compliance. An association might want to explore other enforcement options, including the collections process, for example. And if you don't follow the correct process to levy fines that are enforceable, then we can't try to collect those fines for you. And so I would estimate that when we get accounts referred to us for collections, I would say well over half of the fines that we see on homeowner ledgers, we have to tell our clients are uncollectible. And so we want to quickly recap the steps that are necessary to levy enforceable fines. And so for that, I'm going to hand it over to Katie.
Okay, so one of the first things that needs to exist for there to be an enforceable fine assessed is a rule that has been violated. So sometimes there can be provisions of your declaration that have actually been violated, but more often than not, it's a more specific rule that you're given the authority from your declaration to adopt that has been violated. If that hasn't happened, there's no fine. You need to have a published set of rules or the declaration, even as a starting point. Then the statute requires that there be a fine schedule. Your declaration may be silent. Statute trumps it, and it says that in order to assess fines, there has to be a fine schedule that has been previously published to the owners. So it is not enough to pick a number and put it in the notice, or even send, I would say you can't even send the fine schedule the day before you send the notice of violation. You have to give owners time to comply and actually receive the fine schedule. And that fine schedule has to have a set amount of fines. So please do not put ranges of $50 to $1,000. Pick an amount for your first violation, your second violation, your third violation. You can have tiered violations. Say people painting over their sprinkler heads. You can make that a tier 3 violation that has a higher dollar amount, but it cannot be a $50 to $100 or $1,000 fine, because if it comes to our office, we're going to tell you that the lower amount is the fine that should have been enforced.
What if the fine schedule says at the board's discretion? Is that okay?
No, that's a great question. No, that's not a fine amount. That is letting the board pick. So the board does have the ability after the hearing, which I'll get to in a minute, to go lower. You can always go lower than what your fine schedule says. You can never go higher. There is no discretion to say, oh, it was super bad, so we're going to do it twice, or we're going to double it. Unless your documents actually say that the second violation will be double the first. Then I think there's an argument that, okay, you just have to do math, but there are actual numbers to support it. The fine must also be reasonable. So in your fine schedule, your fines must be reasonable. If you can articulate a reason for a large fine, it might be reasonable, but it has to be reasonable when viewed after the fact by a neutral third party. So you cannot say they have not watered their lawn, $1,000 fine, reasonable, because it's hurting a home value by $1,000 or a community home value. I would argue that that's not reasonable. I don't think that's a well articulated reason as to why. But we have had or have seen for like rental violations that the fine was equal to the amount of rent that the person was receiving, because that was the direct benefit that they were getting from the violation. We can at least go in front of a judge and argue that with a straight face. I cannot go in front of a judge and say that $1,000 fine for an unwatered lawn is reasonable. I think I would even have a hard time with like $100 fine, but it's at least more reasonable, and that's getting into my own views. So don't let your own views of what you think is reasonable prevail over if it's really unreasonable. Basically, be reasonable as a third party would be, not because of your own personal opinions of it. So we have our rule violation, we have our fine schedule with a set amount, and we can assess a fine. Yes? Maybe. The board has to first find a violation, and there is a duty of care that the board has to meet to be able to assess that fine. And the board has to conduct an independent investigation based on objective information and adequate inquiry. So that may be a photo of an unwatered lawn. Okay, you can clearly see that the lawn is unwatered, it's dying, you've driven by it. Independent investigation, objective information. Where that's harder is noise complaints, because owners complain about other owners, and you can't, unless you schedule a time to go in, which is part of the investigation, you won't be able to hear it. We do sometimes have people come with like audio recordings or video recordings. They're not as great, especially if there's no video attached, but it's all part of the investigation. So once you have your violation, the board has met their duty of care, they have investigated, they've determined that there is a violation, you have your fine schedule, that's when you send out a notice to the owner in accordance with the fine schedule, either telling them there's a violation and this is a warning, or it's a letter that has the fine amount and says there's a violation, and they have an opportunity to be heard. It is not an appeal. The fine has not been assessed yet. The notice says, here's a violation. This fine may be assessed or will be assessed after X amount of time if you do not request a hearing, or some of your documents may require that you schedule the hearing in advance. And so you have to look at your documents to see if, okay, the notice must require the date, time, and place of the hearing. And if the owner doesn't show up, that's different. But it's not that they request a hearing, you have to set it for them. So your notice says, request a hearing. This is all the due process. Request the hearing and the fine amount. If the owner does not request the hearing, then you can assess the fine. It is not the fine has been assessed and you can appeal, that's where people get tripped up the most. They say this fine has been assessed against your unit. You can request a hearing or you can appeal. That's not good enough. All right, Valerie, anything you want to
Yeah,
fill
I
in?
just want to emphasize that last point, because that is indeed the biggest mistake that we see is fine notices or violation notices that say, you XYZ violation, we have fined you $50. You have the right to request a hearing about this fine. The whole difference between due process and an appeal is that due process happens before the fine is assessed, and appeal happens after the fine is assessed. The other difference is that due process is required by law, where an appeal is not. You can decide to let an owner appeal a fine, that's fine, but it's not required by law. It is, however, required by law that you give owners due process notification before the fine is assessed. And I see a question in the chat about when a prior letter offers a hearing. And I think that depends. Every single time you assess a fine, you have to give them a due process notification. So it doesn't matter if you sent them a letter in the past that gave them a due process notification. It doesn't even matter if your fine policy contains a due process notification. Each notice of a proposed or potential fine has to give them due process. The only exception to this might be if you are dealing with an ongoing or continued violation where you have sent multiple notices of fine. You went through the warning process, the first fine, the second fine, the third fine, and then you decide we're going to be fining this person $25 a day until they correct the violation. I think you can send an initial notice of that ongoing fine that must include a due process notification. And then I don't think you have to send them a notice every single day for that continuing fine or violation with a due process notification. However, we have had accounts come to us where an association has been fining somebody $25 a day for months on end without sending any additional notices. And there's a point beyond which that gets a little bit hard to defend from a due process perspective. So my suggestion to clients in that situation is send a notice once a month. Say, hey, by the way, we're just reminding you, you're being fined $50 a day or $25 a day for this XYZ ongoing violation. We already gave you a due process notification. We are reminding you that you continue to have due process rights and can request a hearing about future fines, but don't let too long go in between those notices, even if you have followed the process correctly up to that point. I also want to emphasize something else Katie mentioned, which is some association governing documents have extremely complicated and specific enforcement procedures that you are required to follow in order to assess enforceable fines. And honestly, some of them are written so poorly and so specifically that it makes it essentially impossible to assess an enforceable fine. So make sure that you familiarize yourself with the process that's required by your documents. And if you have one of those documents that is really ridiculous, consider budgeting for an amendment at some point in the future so you can simplify that process. And the last thing I want to offer is follow your actual fine schedule. The number of times that we get fine notices where, man, they gave a warning letter, they gave the due process notification, and they've got a fine policy, but the fine policy says warning 50, 100, 150. And then the order of fines and the letters is like warning 150, 75, like whatever. So make sure you're actually following the amount of the fines that are laid out in your policy, because if you don't, those fines might be entirely unenforceable, or we might have to reduce them to at least match the amount that's in the fine policy. Katie, did you want to add anything else before we wrap it up for today?
The only thing I'd add is one, have a fine policy, a fine schedule and a fine and enforcement policy. And also if you have multiple places, because we see sometimes your rules will have the fine schedule, and then you'll also have a fine and enforcement policy, which has the amounts. Make sure those amounts match. If you're changing one, you have to change the other, because otherwise you're going to end up in the situation where you have to go with the lower amount.
Yeah, that's a great point. I'll end by saying that one of the things we recommend our clients do every, say, 2 to 3 years, more if there are significant changes in the law, is that the board should schedule a review of your policies and rules and enforcement documents every 2 to 3 years to make sure that they are consistent with how you want your community to operate, that they're consistent among themselves, right? So that there's no conflict like the one that Katie just mentioned. And that they're actually easy to understand. They're well written, plain English, easy for everybody to understand, etc. In particular, one of the things that we tell our clients, for example, is that your collection policy, which I know is not about fines, but it's tangentially related, we've had some really significant statutory changes that have happened in the last 5 years, more than one set of those changes in the last 5 years. So if your collection policy is older than that, or older than 2 or 3 years, you should look at it periodically, look at your fine policy, look at your rules periodically. Maybe even consider budgeting to have your attorney review them every 3 or 4 years to make sure that they're still consistent with state law, that they don't contradict your declaration. And you as a board look at them to make sure that they represent the way that you want your community to operate. That takes us right up to 11 o'clock. So we are done for the day. Thank you all for being with us today, and we'll see you here next week. Bye, everybody.